appended to the respondents' affidavits. The first is a notice to prohibited immigrant in which the applicant is ordered by the Tanzanian Ministry of Home Affairs to leave Tanzania within 3 days by escort. Again, if the applicant wants to take issue with this notice on the basis that she was ordered to leave within 3 days by escort, she must do so in Tanzania and not here in South Africa. Then there is a written notification by the Tanzanian Ministry of Home Affairs to the High Commission of South Africa evidencing the handing over of Bester and the applicant, and I quote, "to you for your further procedures," stop quote. Lastly, there is a confirmation of handover by the High Commission to the South African immigration officials. According to the respondents, these two last mentioned documents were exchanged by the relevant parties at the airport before the departure of the aircraft back to South Africa on the late evening of 12 April 2023. At the hearing of the application, it was contended by counsel representing the respondents that officials on the South African side did nothing wrong and that they only acted on the directions of the Tanzanian officials. The applicant should therefore litigate in Tanzania and not in South Africa, the argument went. I do not agree. It is patently clear on their own version that the respondents willingly participated in the handing over event at the airport, believing that such handing over was done in terms of international law and in terms of the law in Tanzania. Moreover, the respondents were aware that the applicant was handed over for purposes of her prosecution in South Africa. What they did not realize was that such handing over of the applicant was in fact an extradition without any process and not a deportation. This is what the law says, as we have seen herein before. But this is not the end of the matter. The answering affidavit on behalf of the Director of Public Prosecutions, the Minister of Police, and of Captain Flyman states that when the applicant was handed over at the airport by the South African High Commission to officials of Home Affairs, she did not, be it verbally or otherwise, offer any resistance or protest. On the contrary, she informed all and sundry that she wanted to return to South Africa to her children, it is said in the affidavit. In State versus Mahala and another, 1994, 1 SACR 510, the Appellate Division here in South Africa held that where the transportation of a person investigated for criminal offences from a foreign jurisdiction to South Africa is consented to by such a person, there is no violation of such person's fundamental human rights or international law, and that being so, the South African Criminal Court will have jurisdiction over such a person. In State versus December 1995, 1 SACR 438 Appellate Division, the appellant contended that he was arrested and abducted from the Ciskei by the South African police and relying on State versus Abraham referred to above, he argued that the criminal court lacked jurisdiction to try him. In that case, the court found that where the appellant was not forcibly abducted and his return to South Africa was voluntarily, there was no infraction of South African or public international law. Consequently, the decision in Abraham's case did not preclude a South African court from exercising jurisdiction to try the appellant. In the Mohammed case referred to earlier, the consent of Mohammed to his removal to the United States also became an issue of contention. In that case, he was removed in order to face a criminal charge where he could be sentenced to death. The Constitutional Court remarked that it is open to doubt whether a person in Mohammed's position can validly consent to being removed to a country to face a criminal charge where his life is in jeopardy. The court, however, assumed without deciding that a proper consent of such a nature would be enforceable against Mohammed. To be enforceable, however, it would have to be a fully informed consent and one clearly showing that the applicant was aware of the exact nature and extent of the rights being waived in consequence of such consent, the court stated. In the present case, I have no hesitation in finding that the applicant was well aware at the time of her handing over of the charges that could be leveled against her upon her arrival in South Africa. She nevertheless consented to her removal from Tanzania to South Africa because she wanted to be with her children. At the very least, she had willingly acquiesced to her transportation back to South Africa. Based on the decisions of the Appellate Division in the cases of December and Mahala, to which I have referred, and which cases I am bound to follow, I therefore find that the application cannot succeed. I make the following order. The application is dismissed with costs, including the costs of 2 counsel where so employed by respectively the 1st to 3rd respondents and the 6th respondent. Thank you. The court will now adjourn.